That's quite all right. Ladies and gentlemen, welcome to tonight's Board of Appeals hearing. Before we begin, let me introduce the members of town government that act as advisors to this board. To my left is Paul Hennings, counsel to the board. To his left is David Flynn, assistant planning director. To his left is Tom O'Brien, a planner in the planning department. To his left is John Bongino, town building director. Now let me tell you why you're here tonight. New York State statute requires that any town that adopts zoning must also have a board of appeals to act as a relief valve so that those persons aggrieved by strict application of the zoning ordinance can seek relief without the expense of going to court. Town board can give Board of Appeals additional powers, such as special exception approvals, site plan approvals, etc. In Smithtown, the town board has given this board authority regarding certificate of existing use and some special exception uses. The most common kind of applications before the board are area variances. Area variants deal with dimension, as lot area, frontage, height, setback, and parking spaces. New York State statute mandates that the board must consider the following five criteria in area variances. When you come to the podium to present your application, you need to address these 5 areas. They're posted here for you. Number 1, whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created. Number 2, whether the applicant has other feasible alternatives. Number 3, whether the variance is substantial. Number 4, whether an adverse impact on the environment will be created. And number 5, whether the alleged difficulty is self-created. The statute requires the board to balance the interest of the applicant and those of the neighborhood or community. This statute further requires that the board shall grant the minimum variance it shall deem necessary and adequate, and at the same time preserve and protect the character of the neighborhood and the health, safety, and welfare of the community. The board has the power to impose reasonable conditions for granting variances. Special exception variances are different than area variances. When we have a special exception application before us, I will explain the different criteria. Regarding procedure, cases will be called in order that they are advertised. When your case is called, please come forward, submit your affidavits and mailing receipts to Mr. O'Brien, and then you will be sworn in at the podium, and you will be given the opportunity to explain to the board why you need the variance. After the applicant is done speaking, all interested parties will be given one opportunity and only one opportunity to be heard. So please, organize your thoughts, keep your remarks factual that are related to the case. Then I will ask the applicant to come back to the podium to answer your concerns. The board will then close the case and reserve decision. After all the hearings are closed, the board will review the cases and decide some of them. Others will be reviewed at a later date. There are 3 ways to find out the results of the case. Number 1, you can wait until after the public hearing, but there's no guarantee the board will act on your case tonight. Number 2, you can call the planning department tomorrow afternoon. And number 3, applicants can wait and be notified by mail. We do have some adjournments, and I will tell you what they are. The first adjournment is case 16524, 155 West Main. That's Arthur Avenue. Was there anyone here for that one? That has been adjourned to April 24th. And the next case that is adjourned is case 16531, DLJ Ventures. It's the Kings Park Garden Center. Anyone here for that one? Okay. Let me tell you, we can't hear that case until it is decided in the courts who owns the property. So I have adjourned it to April 24th. But what I would tell you to do is to call that day to make sure it's on. All right? Until I get a decision, I can't hear the case. All right? I'm sorry that you had to come down, but just keep calling to make sure that we're not keep adjourning it. All right? And I appreciate that. Yes. Absolutely. No, the applicant must be here. Everything has to be on the record. So at that next, when it is heard, then you can show the letter. Okay? Thank you so much. First case tonight is case 16640, Christina Whalen, 819 Town Line Road, Hauppauge. Location, north side of Town Line Road, west of North Hoffman Lane, Hauppauge. Property zone R10. Request variance, reduce the minimum rear yard setback from 50 feet to 40 for an existing 450 square foot deck. Reduce the minimum side yard setback from 12 feet to 1, and total side yard from 28 feet to 15 for an existing 160 square foot shed. Hello. May I have your name, please?
Christina Whalen.
Okay. Christina, make sure you're talking to the microphone, dear.
Christina Whalen,
And your address?
819 Town Line Road.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes.
All right. Would you like this gentleman to speak for you?
Yes, if that's all right with the
That's
board.
fine.
Thank you.
Okay.
Go ahead.
Okay. Let me have your name, and would you spell your last name for me?
Gerard Whalen, W-H-E-L-A-N.
Okay.
Okay.
And your address, please?
Pardon?
Your address.
41 Carlton Lane, Hauppauge.
Okay. Will you raise your right hand, please? Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you. You want to tell us why you're here, please?
Yes. We are here to request variance to reduce the minimum, oh, am I too close? Oh, it's ringing in my ear. To reduce the minimum rear yard setback from 50 feet to 40 feet for an existing 450 square foot deck. To reduce the minimum side yard setback from 12 feet to 1 foot and total side yard setback from 28 feet to 15 feet for an existing 10-foot by 16-foot shed. And to permit an accessory structure in the required side yard. This variance is being requested for an existing deck and shed for the property at 819 Town Line Road. The shed and deck are well maintained and are both aesthetically pleasing in design and enhance the value of our property as well as our neighbors' properties. And due to a steep slope at the back of the, in the backyard and the shed, it cannot be fixed anywhere else because the slope is too demanding. It's down by 7 feet in an area of just 15 feet from the back. It goes from 7 feet down when you're in that 15 feet area. As I said, it's well kept, the area, and there's no way it can be shifted, you know, without just taking it away. And that's about all I have to say, though.
That's fine. Thank you. Planning? Gentlemen? Okay. Thank you so much.
Thank you. Thank you, Board.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second.
It's regularly moved and second. All in favor?
Aye.
Aye. Motion carried. Next case is case 16641, Pedro Contreras, 267 Lilac Lane, Smithtown, location, south side of Lilac Lane, west of Brookside Drive, Smithtown, property zone R21. Request variance to reduce the minimum front yard from 50 feet to 37 for an existing 96 square foot porch. Reduce the minimum front yard from 50 feet to 41 for proposed 234 square foot second floor addition. May I have your name, please?
Yes, my name is Pedro Contreras,
And your address, Pedro.
267 Lilac Lane, Smithtown, New York.
Okay, raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Okay. Would you like this lady to, no?
No, I'm not speaking, so I move over.
You're not speaking. Okay.
I'll put it on the record, this is my better half.
She ran right away. All right. You want to tell us why you're here, please?
Yes, I am here requesting a variance to reduce the minimum rear yard setback from 50 to 40 feet for an existing, oh, I'm sorry, I'm reading the wrong one. Look at me. Requesting a variance to reduce the minimum front yard from 50 feet to 37 for an existing 96 square foot porch, and reduce the minimum front yard from 50 feet to 41 feet for a proposed 237 square feet second floor addition. We are requesting the variance for our existing home. When we purchased the home, we're not making any modifications. We're not going out any further or anything like that. It's the way the house was built when we purchased it, 8 years ago, and when it was originally built, I think 50 or 60 years ago. With regard to addressing your considerations, it's not an undesirable change because we're not changing the way it exists right now, the way it was originally built. The benefit that we're seeking, again, it's not that it's going to be achieved by any other method other than eliminating the front porch and eliminating the front of the house, because it already, again, it's the way it was originally built. There was no additional, no amount going further into what it is right now. And the requested variance is not substantial. We're not changing it. We're not, again, not extending it any further than what it currently exists. It would not have any adverse effect or impact on the environment because, again, it's been that way for 50-plus years. And again, this alleged difficulty was not self-created. Again, I kind of sound repetitive, but it's the way the house was built originally. There's no change to that. And that's it.
Okay. Planning? Gentlemen? Okay. Thank you so much.
Thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second.
Regularly moved and second. All in favor?
Aye.
Aye. Motion carried. Next case is case 16642, Jerry and Carolyn Florio, 16 Cayuga Place, Comac. Location, south side of Cayuga Place, west of Tompkins Court, Comac, property zone R10. Request variance to reduce the minimum rear yard setback from 50 feet to 38 for a proposed 528 square foot first floor addition and an existing 166 square foot deck. Reduce the minimum side yard setback from 12 feet to 11 and total side yards from 28 feet to 25 for a proposed 528 square foot first floor addition, increase the maximum gross floor area from 25% to 28% for a proposed 528 square foot first floor addition, increase the maximum side yard paving from 25% to 42%, reduce the minimum side yard from 12 feet to 1, and total side yards from 28 feet to 12 for an existing 74 square foot shed. Hi. May I have your name, please?
My name is Jerry Florio.
And your address, Jerry?
I live at 16 Cayuga Place in Comac.
Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you. You want to tell us why you're here, please?
We have, I guess everybody has a backyard, but we're looking to get a variance for the backyard, the extension, because we have a big family, and my kids, my grandkids are really terror when they come over, with toys, and we need the big room for the holidays, and basically is we need the space to occupy it, to take that fill, and when it comes to holiday, it would be nice to have a table there and have a enjoyable holiday, and that's it.
Okay. You want to address the paving?
Try to explain to the gentleman. I couldn't read it because I can't read it. I don't understand it. But it's in the front of you, I think.
Yeah. It's the paving in the side yard. You're only allowed to have 25% of the property paved in the side yard, and you have 42%.
Okay.
So that's what the question is.
Is the pavement in the side yard? We have the asphalt as right now there. That's what you mean to pave it?
Yes.
Okay.
I think the question is, the ordinance limits the amount of paving to 25% of the side yard. And I think the question is why do you need 42%? Why do you need so much pavement?
Well, when we did it by, as the contractor required, and basically I didn't know the percentage of that. So, it was just his word to say, go ahead, do it, and I let him do it. These are my own words, I'm sorry.
That's all right. No problem. All right. Any other questions, gentlemen?
No question.
Thank you so much.
Thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
It's regularly moved and second. All in favor?
Aye.
Aye. Motion carried. Okay, gentlemen, I'm going to read both cases. Okay. Case 16643, Smithtown, Long Island Hotel Properties, LLC. It's 110 Motor Parkway. Location, north side of Motor Parkway, east of Moreland Road, Hopog Property Zone, LI. Request variance to reduce the minimum required parking from 382 spaces to 374. Increase the maximum floor area ratio from 42% to 52%. Reduce the minimum required 1,800 square feet of site area for each guest room to 1,469 square feet. Okay. Next case is case 16644, Smithtown, Long Island Hotel Properties, LLC. Again, it's 110 Motor Parkway. Location, north side of Motor Parkway, east of Moreland Road, Hauppauge Property Zone LI. Request variance to increase the maximum floor area from 42% to 52%. Increase the maximum building height from 35 feet to 45 feet. Reduce the minimum required 1,800 square foot of site area for each guest room to 1,031.5.
Madam Chairman, members of the board. Bram Weber, 290 Broad Hollow Road, Suite 200E, Melville, for the applicant Smithtown Long Island Hotel Properties, LLC. Alan King, professional engineer and partner at Cameron Engineering, will testify to the parking study which he prepared in connection with this application, in which we just submitted for the record. I ask that the board accept Mr. King's testimony as expert testimony.
Excuse me, are you an attorney?
I am.
Can you tell me the group you're with?
Weber Law Group.
Just Weber Law Group? Thank
Yes.
you.
And I submitted Mr. King's credentials also for the record.
Thank you.
If you would like me to qualify him further, I will certainly do so. This application is for 3 variances required by the proposed subdivision of the property located at 110 Motor Parkway, Hauppauge, into one property on which the existing Smithtown Sheraton will remain, and the other property, the subject of hearing 16644, into a site of a future Spring Hill Suites hotel. For this application, 16643, the existing Sheraton Hotel will remain as is and is not being expanded or modified in any way. The applicant is required to seek 3 variances: to increase maximum gross floor area from 42% to 52%, to reduce the number of parking spaces by 8 spaces from 382 spaces to 374 spaces, and to reduce the required square feet for each guest room from 1,800 square feet to 1,469 square feet, all due solely to the proposed subdivision of the property into 2 separate lots. Currently, the entire property is approximately 10.46 acres in size and is zoned light industry. The existing Sheraton Hotel was approved as a special exception use and was constructed in 1980. In order to subdivide the property into a 7.05 acre property on which the Sheraton will remain, and a 3.41 acre property for the future construction of a Spring Hill Suites hotel, the existing special exception approval for the Sheraton must be amended, and a public hearing was held on that application before the town board on September 15th, 2011. Because of the reduction in land area on which the Sheraton sits from 10.46 acres to 7.05 acres, even with no modification whatsoever of the existing hotel, the property now requires the variances which are the subject of this hearing. I'd like to ask Alan King now to testify to his parking study and specifically to the variance required, which is required by the reduction of the parking spaces from 382 spaces to 374 spaces.
Good evening, Madam, members of the board. As Bram mentioned, my name is Alan J. King, Jr. I'm a licensed professional engineer with the firm of Cameron Engineering. I am the partner in charge of all traffic, transportation, and municipal engineering that the firm does.
Okay. Will you raise your right hand, please?
I will.
Thank you. Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you.
Our business address is 100 Sunnyside Boulevard, Woodbury, New York. And since Mr. Weber really described the application, I'm going to go right into summarizing my parking analysis, which had been submitted to the board. In addition to the full traffic study that we did back in August of 2008, my firm did 3 sets of parking counts at various times on this site. Those were in June of 2008, October of 2008, and the most recent was October of 2011. The most recent counts, as well as a valet parking plan, are described in the letter that was submitted to the town prior to the hearing. All parking counts were scheduled on nights with relatively high projected occupancy and with high projected numbers of attendees at various events being held at the Sheraton. To address a request for updated information from Mr. DeRubius, We did new parking counts in October of 2011. We had done numerous prior to that, as I previously mentioned. The latest observation covered 3 overlapping events with up to 520 attendees, and the hotel was 74% occupied at that time. We observed in a peak condition, and we observed the parking there for almost 4 straight hours, of 389 parking spaces used, with 18 spaces used in the overflow lot, which is the subject of this application. Interestingly, when the 18 were over there, there was like 30-something available on site. So it was a kind of a shifting that went on. People probably were late to an event and just went and conveniently parked. We then projected this up to 431 spaces that might be used if the hotel had been 90% occupied. 90% is what typically a hotel would strive for in their occupancy rates. And we've looked at the Sheraton's rates for a 13-month period, and their average is well below that. So 90% we feel is very, very conservative. The number of spaces can be accommodated by the proposed plans with the proposed shared parking between the 2 hotels. And I want to point out that we're losing 8 spaces on the existing facility, but that's because we're creating connections between the 2 hotels. So the 2 hotels are going to be managed by the same management group, and parking easily can shift back and forth between them. As shown on the valet parking plan, which is attached to the letter that we submitted, it is fairly simple to add 60 additional parking spaces on the site, and that would occur in the rear of the building. It's actually, their events all enter through the rear of the building. So it's very natural to have a valet in place at that location. And that would only be needed for their larger events. So the valet spaces are behind the hotel and will therefore not interfere with general entering and exiting movements into the facility. I also believe that it is reasonable that the 2 hotels would implement a shared parking plan that they could run by the same management company and would have cross-access. I believe this adds at least 18 additional spaces to the available total spaces. And the reason I say that 18 is the minimum, because 18 is provided above code on the Spring Hill Suites site. However, we did look at the Institute of Transportation Engineers shared parking analysis and their parking generation manual to see what would be recommended, and actually the Spring Hill Suites site would really use 60 less than what's provided. So with that layout, you really have 74 more additional spaces that would be available as a minimum on the adjacent site. So to summarize, based on my office's repeated observations of parking demand at significant events at the hotel, and based on my knowledge of the hotels and their use, as well as the proposed valet parking plan, this proposed application will not incur parking overflow onto adjacent streets, and the on-site circulation will not be impeded by parking issues. At this time, Madam Chairman, I would like to return the floor to Mr. Weber unless the board has any questions of me.
Gentlemen, do you have any questions?
I had a question.
Go ahead.
On the Spring Hill Suites site, that one will comply with the parking requirement?
That actually is excess.
Excess? Okay, thank you.
I don't know if it's really a question. After we met and we went out in the field, I did parking calculations.
Yes.
And I think Mr. Weber's presentation certainly seemed credible in terms of what seems to really be needed. However, I believe that legally the parking required is much more than 382 for the existing Sheraton. I sent you an email, but I didn't keep a copy for myself. Do you happen to have it?
I did not.
Oh, okay.
printed.
It seems as though that the ordinance requires 1.25 spaces per room, plus parking for whatever the uses there might be. And the existing conference center is basically a restaurant of 29,000 square feet. And so that would require about 290 stalls for the conference center. And then for 209 rooms times 1.25, I don't remember the exact number, but it's going to be about 240, 250. Putting it all together, I believe the requirement for both sites is approximately 733 or
Right.
730. It seems as though the variance would, if what was advertised is granted, it's not enough. I think it needs to be more accurate. I tried to figure out where the 382 came from. Apparently in 1979, the town code was different, and it required 1 space per room and 1 per 2 employees, plus, well, I'm not sure what else, but the calculations in the 1979 application don't account for 382 either. The ordinance was amended around 1985. Instead of 1 space per room, it was 1.25 per room. But before that, the Sheraton expanded their parking lot. So in 1985, when the town zoning ordinance got more strict, the Sheraton was not non-conforming, they were in compliance. And they've been in compliance ever since. So it would appear that the parking variance for the existing building would be, and I don't have the number handy, but it's something about 150 to 200 spaces greater than what was advertised. So, I mean, I would recommend that it be re-advertised.
You understand where, Mr. Flynn? Did you realize that the ordinance was changed?
I did, and the 382 was based on the prior approval for the site. I think either way, my observations and my analysis support the plan that's in front of this board. The advertising issue itself, I guess I'll let Mr. Weber address that one.
Testimony certainly seemed to support his conclusion. I think that you ought to see the written version. I haven't seen the written report. If it came in today's mail, I probably won't see it till tomorrow. But as soon as I get it, I'll pass it on to you.
I don't think it's in the full,
No,
files.
we haven't seen it, so assuming that the written documentation supports his oral testimony, I think that would be good for the board.
And a copy of the report was submitted also tonight at the as an exhibit for the hearing itself. Just to address this, the number of the variance that we were required to seek from the town, based upon town review and notice of violation and/or denial letter from the town, was 382 spaces. So it was based on 382, which is why we noticed for 382 and applied for 382. To the extent that the town is going to require a different calculation, as Mr. King said, I think the evidence, which we went out to substantiate, would certainly give factual basis to support an additional variance or a greater variance, but the variance that we are seeking tonight was based upon the town's review of our application. At the time, as Mr. Flynn said, the time where there was additional parking that was sought, it was really for a nightclub use and the excessive and the intensive parking that was needed at the nightclub at the hotel, which is no longer in operation at the hotel and has not been in operation at the hotel in quite some time.
Well, I guess we're going to have to adjourn it.
That would be my recommendation.
Yeah.
Just to play it safe. I mean, if you do it the other way, and something turns out amiss, I don't think they're being hurt. I know you have to spend money on mailing again, but I don't think the town board is waiting for this board to act, right? You're pending before the town board right now?
That is correct. We had our public hearing for the town board.
And I don't think, that town board meeting is not until when?
They had it.
Did you have it?
We had our public hearing already for the town board. But again, that was to modify the special exception for the existing hotel and for a special exception for the proposed hotel.
However, they did not make a decision, did they?
That is correct. That is correct. To the extent that on the one particular variance, that we would have to come back to the board with the same evidence, but to justify the larger variance for parking, that's acceptable. I think that the record can reflect and should reflect. We certainly satisfy the requirements for the existing variances that we were required to come to today, and certainly the 2 out of the 3 that we're seeking now. On that first application, the second application, the Spring Hill Suites, is a separate application and therefore really unconnected to the Sheridan parking.
Right. Well, the next meeting is April 10th, and we're overloaded with that. If I give you April 24th, will you be able to send out
Absolutely,
the
yes.
letters and everything?
Thank you.
Okay. And I'm assuming, I'm hoping maybe before that, the town board will make that decision, make their decision. I don't know if they will or not.
The only thing that they were at that public hearing, they had said to us, and we had acknowledged that we needed to come here for variances. So they may very well be waiting for us to have this public hearing.
Okay. All right. So we'll adjourn it to April 24th. I guess, Mr. Flynn, you'll be contacting, or John, as far as what you think that has to be advertised?
We'll work with building. I spoke with the plans examiner yesterday. Yeah, we'll be ready.
Okay.
Yeah.
That's fine.
All right. Okay. Was there anyone here that wanted to speak on this application? Okay. All right, you're adjourned to April 24th? Okay, thank you.
That's the hearing number 1. I've got the second hearing.
I'm sorry.
But this is, that's for 16643 for the Sheridan, but there's 1644 for Spring Hill Suites, which is separate.
Right. That one, yeah, we'll do both at the same time.
Okay, right, but this one we noticed for today, but this the parking issue that's for the Sheridan has nothing to do with the separate lot for the Spring Hill Suites. The 3 variances that we need are not for parking.
Okay. So, well, first of all, I have no secret. We can't act on this one. You know
Understood.
that. You understand that.
Understood.
So I guess they just need to adjourn the first one?
My recommendation, both for your benefit and the board's, is the decision date of both should probably be on the same date. Because if like the clock starts ticking on one a month
Yeah.
before the other, confusion usually happens on the property owner's standpoint of getting the permits in on time. So I think it's better for your client and for the board to, whatever date that might be, that the decision's on the same night.
And I have no problem with the decision being on the same night, but I wouldn't, with the board's permission, I'd like to do the hearing on this one. We're prepared to do it. Like I said, the relief has nothing to do with the parking for the Sheridan, so if we could do this hearing, and to the extent that the board grants closure of this hearing, we'll come back at the next hearing and do the 1 parking variance on the Sheridan.
You sure you want us to close this hearing?
This is yes, this separate hearing.
Okay.
I would, personally, I'd rather you kept them both open. only
Yeah.
Because if there's a problem with the parking, and we had already closed this one, we may condition a cross-access easement on the 2, which may complicate things if one of them's already closed. Because we can't really hear anything on this application that night if we've already closed it.
Fair enough. You'll see. We'll keep it adjourned. That's fine.
All
Okay,
right.
acceptable.
Yeah, I think it'd be better that way.
But I can still do the hearing. I mean, I can still do the hearing. We'll adjourn that as well. Correct?
Okay.
Okay. So again, on hearing 16644, Bram Weber, Weber Law Group, 290 Broad Hollow Road, Suite 200E, Melville for the applicant, Smithtown, Long Island Hotel Properties. Do you have John, I'm sorry, do you have the Spring Hill Suites up? So so the Spring Hill Suites, which is proposed for the lot that would be created adjacent to the existing Sheraton, the 3 variances are required in order to permit the construction of that hotel, which is proposed as a 144-key limited service Spring Hill Suites hotel. The property size is 3.41 acres, and it is to be subdivided from the 10.46-acre site. Spring Hill Suites is proposed at 77,135 square feet, is an all-suite business hotel, does not have meeting rooms or catering facilities for outside use. In order to construct the Spring Hill Suites Hotel on the 3.41-acre lot, 3 variances are required: to increase maximum gross floor area from 42% to 51.9%, to increase maximum building height from 35 feet to 45 feet, and to reduce the required square feet of each guest room from 1,800 square feet to 1,031.5 square feet, all due solely to the proposed subdivision of the property into 2 separate lots. The Spring Hill Suites will comply with all other dimensional requirements in the LI zoning district. The economic development, job creation, and tax benefit potential of a new hotel on what is now an underutilized parking lot is clear. Additionally, on behalf of the applicant, we submit to you that the variances requested in this application will have no detrimental effect nor any undesirable change on the health, safety, welfare, or character in the neighborhood or the environment. The property is surrounded by commercial uses and complements the business nature of the surrounding properties. The variance is the minimum required and the only method by which to construct an economically viable hotel on the parcel identified for future development on the 1979 approved site plan for the Smithtown Sheraton Hotel. We do not believe the need for variances was self-created, as the site of the future Spring Hill Suites Hotel was identified as a parcel for future development on the 1979 Smithtown Sheraton Hotel site plan. And by virtue of the subdivision to locate each hotel on a separate parcel, the reason why these variances are required. And that concludes my presentation.
Yeah.
I think for the record, a couple of the variances are somewhat substantial. However, the location of the property is somewhat unique. It's very far from a residence district in the town. As you know, these are on Motor Parkway, and the Tri-Tech office buildings and the existing Sheraton are as high or higher than the proposed building. I think the Tri-Tech office building might be double the height of this. So the nearest residence in the town of Smithtown is probably a quarter to a half mile away, and the terrain is such that I think it would be very difficult for someone to see this building from a home. And even if they could, it would be very far in the distance. So I think the impact on nearby residential properties is really non-existent. And I don't think that the height impact for a hotel has any adverse effect on nearby industrial properties.
Thank you very much.
Thank you.
Okay. So the planning department will be in touch, and then we'll see you on the 24th.
Thank you.
Thank you so much. Okay, let me try to get these in order. This is 43, this is 44. Okay. Okay. Thank you. This is 43,
43,
and this is 44.
44. Thank you.
The next application is case 16645, Thomas Bisello, 499 Veterans Memorial Highway, Smithtown. Location, north side of Veterans Memorial Highway, west of Ledgewood Drive, Smithtown. Property zone R21. Request variance to reduce the minimum side yard setback from 16 feet to 1, and total side yards from 34 feet to 33 for an existing 120 square foot shed. Reduce any distance from any lot line from 2 feet to 0 for an existing 73 square foot shed. Increase the max rear yard paving from 25% to 88%. Reduce the minimum side yard paving setback from 1 foot to 0.
Good evening, Madam Chairman, members of the board. My name is Vincent Tremarco. I represent the applicant. I've submitted the affidavits of posting and mailing to Tom. I'm sure the board has visited the site. As you know, it's on Veterans Highway. If you look at the survey provided, the setback of the house is almost 64 feet. And I say that because one of our requests, which seems very substantial, but given the fact that they really can't use their front yard because it slopes down to Veterans Highway, they have a substantial amount of paving, whether it be asphalt or paving blocks. It's pretty busy back there, but again, you can see there's a swimming pool. Not that that's a subject of this variance, but there were other variances that we've gotten in the past. We kind of forgot that he overpaved the property. If you look on the east side, the paving is right to the line, and that's why we asked for that variance from 1 foot to 0, and it's pretty close on the other side too. There were 2 sheds that we're asking for variances for. Again, we don't believe that that is substantial, and it kind of accommodates the swimming pool and the storage for the swimming pool. The 2-story garage at one time had an accessory use upstairs. We've eliminated that in conformance with town inspections, and it's merely used for storage now. So we don't think this will change the character of the neighborhood. As I said, it's set back from the front yard almost 64 feet, and the rear is the only place where you could enjoy this property because, as you know, Veterans Highway is a very heavily trafficked road. Whether the benefit sought could be achieved by some other method, well, I guess we could pull up some of the pavers, but to what end? I don't believe any of the neighbors have any objection. The property is all fenced in. And if you look at the survey, you'll see that drainage basins have been put in right next to where there's a circle with 343. Right adjacent to that is a drainage basin. And next to 344, there's another drainage basin. So there isn't any issue with respect to water running off the property. It was specifically designed so that these drainage basins would catch all water and keep the water on the property. Whether the variance is substantial, I guess you could say yes, it is substantial with respect to all of the different things in the backyard, but I think the basic reason for the ordinance was to make sure there was enough drainage, and most times natural drainage because of the planting of grass in the back. But again, they provided for that, as I've indicated. Whether the proposed variance will have any effect on the environment, it's basically a one-family house. The variances that we're requesting have no effect on the environment. As I said, the only issue would be water runoff, and that's all set up with catch basins. Was the difficulty self-created? Yeah, we did. We paved the back of the house, but as I said, that's really the only place where they can enjoy the property You can't even sit out in the front of the house because of the traffic on Veterans Highway. So we ask the board for its favorable consideration. If the board has any questions, I'll try to answer them.
Mr. Tramarko, didn't we hear this once before?
For different variances, yes.
We did not hear it for the paving?
No. I think I know it slipped by me. I'm not so sure that the building department caught it. And if we did get the variance, well, fine, but I don't remember that.
I think there was a paving variance, but it's not as extensive as today. That's my recollection. I think I
Okay.
looked it up yesterday, the old case.
The okay. Did
Yeah.
we make a decision on the?
It was approved.
It was approved. And now you're telling me that
It's more
it's
substantial than
more
it was.
substantial now?
Correct.
Okay. Okay, planning, is there anything?
A couple of things. When the first application was approved, the garage in the back, that says a two-story garage, it says frame garage. The pictures show that it had 3 garage doors, and today it has none. Is that actually used as a garage?
Well, I don't know that they park vehicles in it since there aren't garage doors, but the use is storage.
Okay. Thank you. The second thing is if the board approves it, the planning department would recommend that the paving that encroaches on the neighboring property be removed to the east. And I think also to reinforce Mr. Tramarko's comments, the property is rather unique. It has a school behind it and a school to the east of it. There aren't many properties that have a divided highway in the front and surrounded on 2 sides by schools. But having said that, also, I inspected the property with you, Madam Chair, on Monday. The property is very well maintained and appears to be a good neighbor for the neighbor to the west. So even though there's a lot of pavement, it's as neat as a pin.
Do you know
Thank you.
where he's talking about as far as, do you understand where he's talking
Yeah, I
about?
can see it on the survey. It's on the easterly side of the property, where it encroaches on the easterly neighbor, which is I guess it's about a foot. We'll take care of it.
Okay. Gentlemen, any other questions? Thank you very much. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second?
All right, regularly moved and second. All in favor?
Aye.
Aye. Motion carried. Okay. Next case is case 16646, Vincent Vivolo, 109 Oakside Drive, Smithtown. Location, north side of Oakside Drive, east of Meadow Road, Smithtown, property zone R43. Request variance to increase the max FAR from 750 square feet to 2,304 square feet for proposed barn. Increase the maximum height of an accessory structure from 15 feet. We have amended it to 26 feet. All right, for the proposed barn.
Yes, good evening, Madam Chairperson, members of the board. My name is Steve Bertolino. I'm the attorney for the applicant. My office is at 130 West Main Street, East Islip, New York. Without rereading the call of the meeting, Madam Chairperson, this application, as you know, is for a barn, but it's also for the replacement of an existing barn that was somewhat 40 years old. It was a 20 by 36. It was on the existing survey. We did receive a building demolition permit from the building department. From what I was informed, that barn was in a dilapidated condition and may have suffered some damage in the last hurricane when several trees on the property were downed. That being said, the applicant proposes to build this new barn, which I've handed to the members of the board a somewhat schematic. This is a packaged barn, if you will, something that you can go online, research, and purchase it. The applicant has 4 horses that he'd like to install here. The barn would be in compliance with all relevant New York State codes for the stabling of the 4 horses. And the footprint is a 36 by 36, whereas the previous barn was a 20 by 36. I think the big difference bringing the square footage into the equation is the second-story hayloft. Because of the size of the barn and the amount of horses, we anticipate storing all of the hay in the loft of the barn. And of course, when you factor into that equation, the square footage goes up tremendously. We do not believe it would be an undesirable change to the neighborhood. I personally drove through the neighborhood, and although there doesn't appear to be many stables or barns there, you can clearly see going up Landing Avenue that the nature and character of this particular part of Smithtown certainly lent itself to horses in the, maybe not near past, but in the past. And as you get up onto Oakside Drive, where this property is itself, there are several properties up there that do have detached structures, some of which, at least from the road, appear to be well above 15 feet, although I didn't have the permission to go out and measure. And going from an aerial view from Google, it is very difficult to see because this area is it's an R43 zone, which is 1 acre, I'm sure you're aware. This particular parcel is about 2.5 acres. And because of all the large parcels, it's very difficult to get a feel. But I would submit to the board that because it is such a large parcel and because we've nestled this barn all the way into the back corner, some 400 feet off of Oakside Drive, I do not believe it would be an eyesore or a detriment to the community whatsoever. Although there is 2 homes behind the parcel, it appears that those 2 homes are also quite a couple of hundred feet from this particular structure. I believe that once the vegetation grows in the spring and the summertime, the barn may not be that visible at all, at least from Oakside Drive. You may get a glimpse of it, and maybe from the adjoining property owners, you may as well. I do not believe that this benefit could be achieved with a smaller barn because Mr. Vivullo has a couple of dozen horses that he has throughout New York State. He would like to keep some home with his family to maintain 4 horses on this property, and I do believe that is within the code of Smithtown for this size parcel. He needs this size barn to accommodate the feed, the hay, and as well as complying with New York State with respect to the barns. Item number 3 is a difficult thing for me to stand here and say that this is not a substantial application. It certainly is. And at first glance, we're not looking for, a 10% variance. We're looking for quite a substantial variance. But I would submit that if you do take into account what I've just said earlier, that we're replacing a 20 by 34 barn with a 36 by 36 footprint, and the previous barn having existed since at least 1969 and being much closer to the street and much closer to at least the neighbor to the east, I don't believe that the substantial nature of this barn is actually a detriment. As far as the adverse effect on the neighborhood, as I said, I did drive around. I believe this parcel has been enhanced in the last year or so that Mr. Vivullo has owned it. He has cleaned up the parcel quite a bit. He has fixed up the house. He has renovated it substantially. And I think it actually adds to the nature and character by building a structure of this character. Again, going up Landing, you can see many of the old barns. This is a new barn. This would be keeping in the nature of character of this part of Smithtown, I would imagine, for many hundreds of years. With respect to the self-created portion, this barn had been started. Unfortunately, I do have to apologize on behalf of my client for that. It is my understanding from what I've been told is that the barn that was existing on site was damaged with the hurricane. It was taken down. The homeowner unknowingly received a package plan with a seal on it, which I have in my possession. he was under the impression that that was sufficient. He did call the town of Smithtown. He asked him about the barn, and his understanding was that Smithtown didn't actually address barns in their code, and he did not put it together that a barn was an accessory structure. Therein lies the problem why this structure had been commenced, although the only thing that's in there is really the post. It's like a post and beam structure, if you're familiar with that. So as it stands today, if you've looked at this side, if you looked at photos, you would see that it is somewhat self-created, but that was just a truly honest mistake on behalf of Mr. Vivullo. We're open to any questions, of course.
You know, we do visit all the properties.
I do.
And we were there yesterday. I don't know how the other board members feel, but we may put a condition on this, that they do plantings.
I don't think that's a problem, Madam Chairwoman.
Okay, in the back, so just to soften the impact to the neighbors.
No, I understand when you say in the
I'm
back.
not saying this is going to be approved, not approved. And the other thing is, there's no LWRP, so there's no action tonight. You understand
I
that?
understand that.
Okay. All right. Planning?
No comments, thank you, Madam Chair.
Gentlemen?
No question.
All right?
Okay.
Okay, thank you.
If I can just, the memorandum I have from the building department does indicate that the WLRP was approved.
No. I don't think it was approved by the town board.
Any possibility you could see what you have?
No. It wasn't approved, was it? Okay. Okay. Is there anyone here that would like to be heard on this application? Come up, please. You can bring them to right here. That's quite all right. Thank you. All right. If you want us to keep these, we'll look at these, but for us to keep them, they have to be labeled with your name when you took this date, with the addresses and everything. If you just want us to look at them, now we can do that. You can't leave them tonight unless you label everything. Yeah, okay. You want to look at these? Okay. Good, go right ahead. Let me have your name, please, and spell your last name for me.
Larry Teitelbaum.
Use the-
Larry Teitelbaum.
Mhm.
Teitelbaum, 111 Oakside Drive, Smithtown.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Okay.
Before I start listening to the presentation, it was mentioned that it was approximately 2 1/3 acres or 2 1/4 acres. I know on Google, on Oakside Drive, they list the acreage of most of the houses, and this one is listed at, I believe it was either 1.9 or 1.95 acres, but definitely not over 2 acres. I submitted photos of this property. This structure, as I'm sure you saw in the examination, can be definitely seen from Oakside Road. It can be seen from my house. It's massive. It, in my opinion, does not comply with Article 1 in that it is a most undesirable change in the area. Oakside Drive, we've been there for approximately 30 years. You got trees all over. Most of the houses are somewhat wild in nature. The front, all you do is see trees in the back. My guess is about 90% of the trees on 109 were removed prior to the building of this barn. The barn is as far from the 109 house as possible. It's all the way down at the end of the property, far closer to my house, my swimming pool, and to the back neighbors. The lack of trees and this structure, which is approximately twice the height of the structures allowed in the code, and on the original notice I got, approximately 3 times the square footage that's allowed in the code. There is also an accessory, I'll call it road, that goes from Oakside Drive, it's a dirt road, all the way to the back of the property. The rest of it is all grass. I think there's only 1 tree there. So it appears to me that there's going to be a decent amount of commercial traffic going to and from this massive structure in back of the house. That's undesirable. The aesthetics are undesirable. It's not the way it was when I moved in 30 years ago. It's the only structure on Oakside Drive that stands out like that. And I would hope that the town board consider this in their application. Thank you.
Thank you. Anyone else? Come up, please. Okay. You're welcome.
Good evening. Good evening.
Get a little bit closer. Let me have your name, please.
Good evening. I'm Kim Titlebaum. I live at 111 Oakside Drive. I am the neighbor to the slight east of 109.
All right, raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
Absolutely. My husband, I can't improve upon what he has said, but I must point out when we moved in, numerous people had horses. Now there is not 1 horse in the area. Now, I have nothing against horses. We had horses at 109 for 30 years, and they were very enjoyable. But here's my point. My understanding of the code for Smithtown would be that it was originated to protect those residents who wish to have a pet horse or 2 or 3, perhaps to ride, but to love and as a pet. What's happening at 109 is in no respect horses who are pets or meant to ride and enjoy as a pet, as a resident. He plans to breed. In fact, I understand he already has bred his mares with the ex-race horses, which he has gotten whatever way, bought or whatever. And what I see is that I'm going to have a horse breeding stable in the back, which will be directly opposite my swimming pool, my garden, and would you like to have that next to you, really? And besides which, legally, I would define this as a commercial venture. It does not belong in a neighborhood. And look, one man's improvement is another man's disaster. He calls what he did to the property an improvement. I call it a disaster.
Thank you. Okay. Anyone else? Okay. Well, if you come back, please.
Yes, just to address both the Titlebaum's assertions. There is, in fact, what we'll call an accessory path. As opposed to a paved driveway, there is just a gravel dirt road. I shouldn't call it a road, it's the wrong term, forgive me. There's just a path going into the backyard to the barn. There is no intent here for a commercial use. This is purely a residential, personal use. Perhaps there might be a hay delivery, I have to admit that. Perhaps the farrier will come to shoe the horses, we have to admit that. But that would be no different whether we had 1 horse or 2 horses or 3 horses. The fact that the applicant has chosen to keep 4 horses as a pet. I can't compare them to cats or dogs, but certainly he does comply with respect to keeping the 4 horses on his property. The issue is not so much whether they're horses, nearby someone's neighbors, as much as whether or not this barn is an eyesore. And certainly we can achieve what maybe the board would want and maybe what the neighbors would want by revegetating part of the parcel, or more precisely, revegetating the easterly property line that adjoins the tidal bounds with perhaps some evergreens, some Leland cypresses that are green all year long and can grow to 20 or 25 feet to offer a buffer if the tidal bounds feel that may help. And I believe the applicant would be willing to do that if he was so required. Thank you.
Thank you. Okay. I'll entertain a motion to close the hearing.
So moved.
Second?
Really moved in second. All in favor?
Aye.
Aye. Did you want to say anything? He's going to be giving you some pictures after he labels everything. You'll bring them up to him. Okay, thank you. Okay. Next case is case 16647, Michael Greco. 9 Trescott Path, Fort Salonga, location northeast corner of Trescott Path and Toland Lane, Fort Salonga, property zone R43. Variance to reduce the front yard on Toland Lane from 60 feet to 55 for an existing 126 square foot deck.
Hi, my name is Judith Travers, and I'm speaking in this matter for Michael Greco. I've given the attorney power of attorney.
He said it's all right. All
Okay.
right, so let me have your name, spell your last name and address.
Certainly, Judith Travers, Travers. I live at 158 Lewis Road in Northport.
Okay, raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you.
All right. I am the previous owner of this property, and as a condition of the sale, I agreed to get the variance for this deck. And it's a reduced, basically, it's really a side yard, not a front yard. At least I think so. And the deck was in existence when I purchased the house, which was 26 years ago. So I really don't think there'd be any undesirable change to the neighborhood. I don't think benefit could be achieved by any other means. The deck would have to be torn out. I don't believe the request is substantial. I don't think there's any physical or environmental condition that would be adversely affected, and the difficulty was not self-created since it existed when I purchased the house myself.
Well, I have to disagree.
Oh,
You are
okay.
responsible. If,
All right.
if there was no CO or no certificate of compliance.
Well, I guess what I've been told as I've been going through this process is back in those days, Smithtown didn't require it, but that was something that I overlooked when I sold the house. It should have been fixed before, and
Right.
until the new survey was presented, I didn't realize that the
Okay.
deck was not in compliance.
Bill, planning? Gentlemen? Okay. Thank you so much.
Thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second?
It's regularly moved in second. All in favor?
Aye.
Aye. Motion carried. Next case is case 16648, Robert Dingaget, 4 Howell Court, Smithtown location, west side of Lincoln Avenue, north of 6th Street, St. James, property zone R10. Request variance to reduce the minimum side yard for a side entry garage from 35 feet to 32. For proposed 640 square foot attached garage, increase maximum paving in side yard from 25% to 66%. And your name, please.
Michael Malkasian. I've given the paperwork in for power of attorney for Robert Dinnigan.
Okay,
There's a little bit of history here.
yes.
And
All right, let me just back you up a little. You need to give me your name, and spell your last name and your address.
Okay. Michael, last name Malkasian, Malkasian, number 6 Orchard Avenue, St. James, New York.
Okay, raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
I do.
Okay.
Anyway, I wanted to give you a little bit of history. Mr. Dinnigan wanted to be here tonight, but his daughter is quadriplegic and something arose and he couldn't make it. Basically, what we're looking to do is a side entry garage. I think there's a difference of 2 feet for the variance for that, and the additional parking is basically to keep the cars off the road. Mr. Dinnigan's daughter has 24-hour nursing, which poses a problem of parking, and then both streets, whether on Grant or Lincoln, are very narrow. In fact, I submitted a photograph of how narrow the street is. So we're trying to keep everything off the road for the neighbors. And also, you also have the situation of school. You know, the teachers all come to the house, the family comes to the house. And it's basically for that reason we ask for the variances, none other. That's basically it, ladies and gentlemen.
Thank you.
You're welcome.
Are there any questions, gentlemen? Okay, thank you. Is there anyone here that would like to be heard on this application? Would you like to be heard on it? Come up, please. May I have your name, please?
Yes.
And
Teresa Evans. I live at 268 Lincoln Avenue, next door to the home.
okay. Raise your right hand, please. You swear to tell the whole truth and nothing but the truth?
Yes.
Thank you.
Okay. And I believe there are a few of us neighbors who need to speak to this. This is a brand-new home, and any plans that should have been underway. The house itself overpowers, it's overwhelming to the houses next door, to any of the surrounding adjacent homes. I have pictures of my own backyard, and the house towers over next to it. And again, I guess our feeling with all of this is that this is not something, it's not a new event to a family that was already there. This is a brand-new house that seems to be squeezed into an inappropriate sized plot, to be perfectly honest. It's a huge home on a narrow piece of property. And I suppose the plans weren't made in advance. You know, and our feeling is, you know, within the neighborhood, that, you know, either the house should have been smaller, so a driveway would fit, or, you know, some other plan. It didn't seem to have a plan. Actually, even as this house was being built, we were all very surprised that a house that size could be squeezed into the plot. And again, we're all assuming that all of the other permits were put in place. This is the first time we've heard about a variance. I have to question whether or not why this variance wasn't asked for ahead of time. In other words, is it like a manipulation of this? Now the house is already built, and now they're saying that, you know, the driveway, what doesn't fit? Why wasn't this variance asked for before the house was built? We just really don't understand. We feel like all of a sudden, it was very sudden, a house that just doesn't fit into the rest of the neighborhood. I do know that my house right now is worth less money because this house overwhelms it very closely. And if my house is worth less money, so are my neighbors. I do have, you know, pictures.
We were there many times.
Yeah, okay.
Okay. From my understanding, and Mr. Flynn, I think maybe, didn't this house come up for variances before, I think, an extension?
I don't remember that.
Yes, I believe it, if I'm not mistaken, when the child became into the accident, I believe that this house came.
This is a brand-new house. It was just started this year. This is not a family who had a problem that they had to extend their home.
Okay.
Yeah.
All right, I may be wrong.
Oh, you know, so and we received no notice of variance. It was, I live on Lincoln. Around the block is Grant. There was a house on Grant that was knocked down, okay? And what was next door to me was the backyard of it. It was, a very long, narrow plot. The house was around the corner, and it was knocked down. And again, this new, very, very big house was built. And apparently and again, it doesn't fit into the neighborhood. And then to ask for even more. Now, if it could have been built, and we just assume that, well, whatever it was, how close it is to my home, I'm assuming that they were following town code. So now they're asking for a variance, but we already think that the whole spirit of the law, even if it's making code now, it's definitely impacting my home value, my privacy, and then to ask to go even further, to put such a wide driveway and more pavement, it really is just going so far.
Okay, thank you.
Okay.
Sure, come on up. May I have your name and spell your last name?
Yes, my name is Carl Hasselreis, Hassellriis. I
And your
reside
address?
at 261 Grant Avenue, St. James. I reside there for the
Now,
last,
Go ahead.
excuse me?
I'm sorry. I want you to raise your right hand first.
Oh, I'm sorry, yes, you
You
bet.
swear to tell the whole truth and nothing but the truth.
Indeed I do.
All right, now tell us.
I reside at 261 Grant Avenue. I've lived there for the past 34 years with my partner, Frank Esposito. Our house is one of the oldest houses in St. James, which was, I believe, indeed established as St. James Park shortly after the Long Island Railroad went through in the late 1880s. Obviously, we've seen a lot of change in the last 34 years. I don't have a lot of facts or figures to bring before you, but I have lived over half of my 60 years in this neighborhood. And my remarks tonight addressed to you, Madam Chairperson and Honorable Board, I'm going to try to narrow to the considerations that you've posted this evening. Number one, considering the undesirable change produced in the character of the neighborhood or detriment to nearby properties, as my neighbor, Mrs. Evans, has already noted, the house is, it's huge compared to the character of the rest of the neighborhood. It's a fairly modest neighborhood, well-treed, long-lived, long-established families. Some families in the neighborhood have been here for multiple generations and are staying, I hope. The fact is, as far as adverse reactions to the neighborhood and effects, when the original house was torn down on September 12th, it was gone in a matter of hours with a backhoe. On September, exactly a week later, on September 19th, a crew arrived to ask us to remove our cars from the street so they'd have room for their trucks and trailers. And I was told by the general contractor that they were going to start with a silver maple on the corner of my front yard. I asked him to check the site plans. He said that he didn't have them, but it was in a it was approximate dimensions based on his approximate dimensions of the Hoffman property, the former Hoffman property, that tree was going to be removed. That tree is still there today. I'm glad he checked his site plans. It's a venerable old tree. However, in the process of clearing this property, starting with a clean slate, to quote the contractor, they eliminated virtually every tree on the property, including an 80-foot spruce, a line of venerable old cedar trees that probably predate most everything else in the neighborhood, as it happens just along the southern border of my property. In the process, while doing so, I videotaped the process going on from my deck. At one point, one of the trees actually fell through my fence, smashing my fence and into my kiwi vines and garden. Promptly, members of the crew came over and started chopping it up and stomping all over my garden. To his credit, the general contractor came over and repaired the fence promptly. But I still have questions as to why immediately after this incident, I called the town to find out if there were proper permits to remove all the trees. And I asked, of course, the contractor about insurance. He didn't want to have any word, and to this day, he didn't want to have insurance mentioned because, you know, it would bring up everybody's rates. Within an hour or so of most of these trees, large trees being come down, 2 agents from the town of Smithtown showed up, a safety officer and I believe an engineer, the engineering department, and chatted with the GC on the site, who told me to get off the property. I don't know what the results of that were, but I was told while they were conversing on the property that if this was a matter of two land sites being cleared, if there were more than one building being built on it, there would have to be a permit for removing all the trees. Oddly enough, again, shortly after this, all work on the site stopped for 2 weeks. I wondered if there was a summons or a stop work order. That's just a little bit of history of how arrogantly this came into the neighborhood. It doesn't address the other problems. I just want you to know that this is sort of how things were transacted. In consideration of your points here, I want to mention that due to the size of the house and the lack of trees now, there's been a significant lack of privacy. I can now sit in my dining room and look out my dining room deck doors and see the second floor, into the second floor bedroom windows of doors, 4 doors to my south. I can see into 1, 2, 3, 4, 5, 6 houses from the south side of my house where I could never see anyone but my neighbor. And then it was through the trees. Drastic change in character, I would say. We're concerned very much so because of the destruction of the trees meant a destruction of wildlife. We're all bird feeders. We've lost bird feeders that were filled for the winter, basically remained filled all winter. The bird population has virtually disappeared. My neighbors will attest to that. It's a change in character. It's a change in our history. It's a change in our heritage in this neighborhood. Our neighborhood consists of many families, and there's a history here. There's a landscape, there's a community. And without any warning, a series of violations occurred that substantially and radically changed the character of this neighborhood. We rightfully take umbrage with this. There was seemingly no consideration. We were told at various times by various people that there was going to be a cute little Victorian go up on the property. We were warned that there might be some problem with a driveway. But I'm also very concerned about how this came about. Again, I have questions. This is the first time we heard about a variation, a request for a variance, excuse me. During the process of the renovation of this property, not only was a huge foundation dug, but there were also many, I would say at least 6 or 10 full trucks of clean fill dumped onto that property. The soil in this neighborhood is a very compact clay rock mixture. It doesn't drain very well. I personally, as a gardener my whole life, am concerned about a higher elevation property beside mine that may drain into mine and not drain well. May puddle us all up, especially if 66% of the side yard is going to be covered with pavement. We don't know whether it's going to be asphalt, pavers, concrete. Quite honestly, a width of that driveway on a narrow street like Lincoln Avenue might very well, if it's asphalt, make it look like there's a new side street. Really,
I'm going to ask you just to...
a bit appalled.
Yes.
Wrap it up.
Wrap it
Yes,
up, please.
Sorry. But I hope you get the the feeling that we all feel that it's been a bit of an arrogant umbrage. We don't have anything personal. We know that the family involved has a child with very special circumstances, and we all feel for that. But a building is going to be building here well beyond when they are living in it and we are all gone. The neighborhood has to survive. We have heard nothing about replacing those venerable trees, some with heritage status. And we are wondering how, indeed, a building permit was given without getting a variance first. We've all had to get variances before we got a building permit. Okay. I'd like to address this to you. In summary, I don't know whether this is a question to ultimately bring to the entire town board, but we all have questions as to how this proceeded without seemingly any breaks on the project. There are variances, we recognize them, and we respect them. We hope that you will take that into consideration, and if there is any special considerations that can be done to replace or preserve the previous character of the property, we would like that considered. Thank you.
Okay. You can't speak. You cannot speak, but let me just tell you, you're waiting here for a decision on your case, no? Okay, because you're not going to have a decision tonight. You know that. Okay, you can stay. Okay. I don't know. I thought, are you speaking on this case or your own case? You can't speak on your own case. If you want to speak on this case, you can. Yeah. Sure. Is there anyone else that wants to speak on this case? Come up, please. May I have your name, please?
Yes, my name is Deborah Capiello. I live at 273 Lincoln Avenue, across from the home being
Okay.
built.
Spell your last name.
Cappiello.
All right. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you.
Yes, basically, I just want to reiterate what my neighbors have been saying about this absolutely huge house that was built quite by surprise, I might add, after speaking initially with the builder when we asked him, again, as was said earlier, it was supposed to be a cute little Victorian, et cetera, et cetera. Well, the house is built. However, the issue of the variance concerning the driveway has been an issue, according to Mr. Dinnigan, from the onset, long before the foundation was even poured, from what I understand. He said he was going to have to ask for a variance. My question would be, why wasn't the variance asked for prior to the building of the house? I mean, it's not apparently a surprise when it was months ago mentioned to me.
We'll check into that.
That's really, I mean, the house is built and evidently built within the criteria. I still have to question that. And I would, I think, just like to just show you the photos, just so you have an idea, really, of what's happened to our little neighborhood. Again, you know, we feel for the family and their circumstances. However, it really has, I feel, been detrimental to the values of the homes in the neighborhood, and certainly the privacy of the two adjacent houses and the houses behind it. We're across the street, we don't suffer that same circumstance. However, I just would like somebody to
If
look.
I will only accept them, are they labeled? I have to be, yes, they have to be labeled. I'll let you sit down and label them. Who took the pictures, what they are, when you took what the date you took the pictures. Okay? And then you can bring them up and we'll put them into the packet. Thank you so much.
Madam Chair?
Yes.
Just, I did some calculations while the hearing was going on. The house complies with the floor area ratio requirement. The lot is about 2.25 times larger than the minimum lot area required in the zoning district. So a house will end up being permitted about 2.25 times bigger than the maximum normally allowed. The maximum permitted house size would be 5,562 square feet, and this measures around 3,900 square feet, 3,856 to be more precise. The second thing, I did some calculations. They don't actually need a variance for paving in the side yard. They may want one, and it may work better for them, But they could comply with the 25% requirement by shifting the driveway and shrinking the turnaround area. You don't have to get rid of it, but by shrinking it. Having said that, that doesn't mean that the board automatically should deny this, but as you know, you grant the minimum relief necessary.
Right.
The minimum side yard is 16 feet. The driveway scales at 3 feet from the side. It could be shifted, technically could be shifted really close to the house. However, if it were shifted to about 12 feet away, no variance would be needed. 12 feet might seem sort of excessive, though. The situation here arises because the lot is basically a double depth lot. It goes from street to street.
Okay.
And so its side yard is larger than the typical side yard.
Thank you. Okay. I'll entertain a motion to close the hearing.
Did you want to come back?
Did he want to come back? Oh, I'm sorry, I didn't even see you there. Go ahead.
I just wanted to say that everything was done per code, which was pointed out. And the house does look larger than it should because the architect made the house rather tall looking. But it does comply with everything necessary. Mr. Dinnigan has lived in this town since he's a young boy. He is the nicest man in the world. He's been my friend for 15 years. That's why I more or less got involved with this project, no other reason. As far as to be a neighbor, you couldn't want a better man for a neighbor. The driveway happens to be on the opposite side of the property of the last two people that spoke. It's not next to their house. There is going to be a landscape package because they've already discussed putting shrubbery alongside of the man's pool because they wanted to give them some privacy. They also, when they did this house to build it, shifted the house back a little further so they'd also get some sun on their pool. They tried to take a lot of things into consideration for their neighbors, and the house has been built because the house they're living in now is too small to accommodate the daughter with her problems. And as I said before, we asked for additional parking to keep the cars off the road for the neighbors' benefit, which if they really sit down and think about it, it's going to be more, it's going to be better for them because both roads are very narrow. I appreciate them getting up and coming out with their concerns. There was nothing done that wasn't done above board. I asked people to stay off the property because of liability issues. I'm there almost every day checking on the property. If somebody had a question, they could walk up and ask me. I'd answer it for them. And I don't think I ever said it was a little house. So I don't believe I ever said that to anybody that was little. From the plans are what they are, but they do fall into the building envelope. And I hope I haven't hurt anybody's feelings or anything. It's not my intention. I've lived in Smithtown for 46 years, and I've never looked to hurt anybody's feelings. I just try to go forward with a project and do what I can do and try and work and get so much accomplished every day. And sometimes it's very difficult when people want to walk on a property when you're working. Other than that, thank you for your time, and I appreciate it.
All right. I'll entertain a motion to close the hearing.
So moved.
Second?
Very moved and second. All in favor?
Aye.
Motion carried. You can bring them up. Thank you. Okay. Okay, next case is case 16648, Jack and Adrian Habashin, 1 Villa Lane, Smithtown. Location, southeast corner of Villa Lane and Stacy Lane, Smithtown, property zone R10. Request variance to reduce the minimum side yard setback from 12 feet to 0 for a second-story deck. Increase the maximum paving in the front yard from 25% to 32%. Increase the maximum paving in the rear yard from 25% to 40%. Reduce the minimum setback of a 4-foot retaining wall from the property line from 4 feet to 0 existing. And your name, please?
Jack Habashian,
Habashian, okay.
and I live at number 1 Villa Lane for the past 40 years. Good evening, members of the board and Madam Chairman. I will be I have to do this part.
Raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
Yes.
Now, would you like this gentleman to speak for
Mr.
you?
Mark Mancini will take over.
Good evening. I'm Mark Mancini, architect, Town of Smithtown, 222 Middle Country Road.
Raise your right hand, Mark. Do you swear to tell the whole truth and nothing but the truth?
I do.
Okay.
Good evening. When you first read the the description of this, and when you're going from 12 feet to 3.6 inches, it's a little, oh my God, what's going on here? But let me explain the property to you. This is a roundabout corner lot on Villa and Stacy Lane. It's on a hill, and Jack's house is overlooking one house, and it's also at the bottom of a hill of the rest of the neighborhood. So he's kind of the house that everybody goes around when they're going out of the neighborhood and leaving, and it's kind of the corner of the neighborhood. Jack's lived here for quite a number of years, and the house originally was built with a deck, and when you meet with clients sometimes and you hear, oh, the deck was always there, you always kind of second guess it, but then I saw a picture that pretty much predated my baby pictures that my mother has of the deck. Originally there when the house was originally built. The house was situated on a lot kind of towards the back line, which they considered the side yard. And the deck kind of encroaches the side.
Ladies and gentlemen, please. Go ahead.
So to reiterate, as far as the porch, the screen porch and the deck goes, it's a typical one that's off of a high ranch house. It's towards the rear of the yard. It's always been there. The builder originally built the footprint of that deck. Of course, over the years, it's been rebuilt, new decking, new bolting, new columns. Jack's a very, very talented person who's kept his yard very, very nice. He did not create the original footprint. It's always been there, and now as he's getting on in years, he really wants to make everything in the yard perfect for his kids someday. He has a retaining wall that is along the driveway, and the back is the rear yard of the property. Over the years, it's changed from being a brick retaining wall and then to a wood retaining wall, and now to a Versalocked retaining wall. We reviewed the structure, and if you look at the drawings, you will see that during the construction of the Versalock, Jack took many, many pictures, and you can see that it was built rather well. It's improved the property, and it's actually taken care of some drainage, since he is at the bottom of the hill of the neighborhood. The water was coming down, and it actually it helped the whole area. Other than that, he's requesting the variance just to square everything away on the property. The house is impeccable. I know if you've probably been out there. It's, yeah, I always say Jack's my hero because the way he keeps his yard is beautiful. And everything's, okay. So.
How does that neighbor feel that from their deck they can look right into their?
After 50 years, is it? Would you like to?
The original neighbors, Mr. and Mrs. Tutrani and their 3 sons, moved in about a month or so after I moved in October of 1971. That house that is below me was built by a spot builder and was left vacant because he had to leave the job. He had problems with construction and some kind of technical difficulties with the town. The Tutranis moved in, and we all became one big family. Some 15 years ago, the Tutranis moved out east. Mr. and Mrs. Stephen Kalakos, a Greek family, moved in, and we adopted them and their family. So everybody's been very, very close, Mrs. Kalakis is now alone. She's approximately 84 years of age. I go down there every day and I have my morning coffee with her. We go shopping together. We go to the doctors and whatever else together. So there's been no problem. The actual level of my deck is just about in line with the ridge of her roof. Somehow or other, that house was allowed to be built as far back on their property as it is, things I could never understand. But originally, Mr. Tutrani, when he first moved in, had water runoff from my property, and I felt it was my duty to do something with my property to prevent his basement from being filled up with water running off my property.
Okay, thank you. Planning? Gentlemen? Thank you so much.
Thank you very much. He arrived
Is
on
there
Saturday.
anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second.
Irregularly moved and second. All in favor?
Aye.
Motion carried. Are you okay? We have one, two, we have two, and then I think we have 4 more cases. One will be long. You all right? Okay. All right, let's do the next 2, and then I'll see how you do. Okay. Next case is case 16650, Helen Duffy, 14 Valleywood Road, Comac, location southwest corner of Valleywood Road and Wyandanch Boulevard, Comac, property zone R21. Request variance to reduce the front yard setback from 50 feet to 30 feet for an existing 192 square foot addition, 17 feet existing. And your name, please?
My name is Helen Duffy, 14 Valleywood Road, Comac.
All right, raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Would you like this gentleman to speak for you?
Yes, I would.
Thank you.
Good evening, Madam Chairwoman, members of the board. My name is Douglas Hines, HYNES, Design Development Group, Post Office Box 808 in Stony Brook.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you.
Good evening, Madam Chairwoman, members of the board. We are the filing representatives of the applicant, Helen Duffy, who is seeking relief from the second front yard setback requirement of 50 feet in the R21 zone in order to maintain an 8 by 24 foot rear addition used as a sunroom. Our building department denial calls the setback we provide as 30 feet, but in actuality, due to a measurement error at the time of the application, we are actually 34 feet from the closest point of our second front yard frontage, which was confirmed by our surveyor today. So I suppose some consideration may want to be given to amending the call of the meeting. We're only requesting 34, not 30 feet.
Okay.
Helen and her late husband bought this house as a VA foreclosure in the late 1970s with the basic structure at issue, the rear addition already in place. She's preparing to sell the house now and, of course, needs to legalize the addition. Since her property fronts on both Wyandanch Boulevard and Valleywood Road, she has to make the 50-foot setback on both frontages. We make 58.7 in the front, as you'll see from the survey, but on the side we are at the 34-foot mark. I'd like to submit for the board's consideration a series of photographs showing the structure and the various perspectives from the property.
Are they labeled?
The photographs are labeled, and by virtue of the presence of the advertising sign in the pictures, you can tell they were taken just several days ago.
Okay. Thank you.
The photographs depict the front of the house, front elevation. It's 3 pages of photographs. I've handed up 6 copies for the edification of the board and 1 for the staff previously delivered with our affidavits of compliance with notification requirements and posting. The rear addition is completely sheltered from view from the north side of the property, the Valleywood Road's frontage, by virtue of the house itself. It's virtually invisible to view from the Wyandanch Boulevard side by virtue of a garage attached to the structure, which has the benefit of a certificate of occupancy, screening the view from that side. We have a very large, oversized piece of property in the R21 zone, over 34,000 square feet, when 21,000 is the norm. And as a result, we've got 130 feet from the addition, from the house actually, to the westerly property line, all naturally screened and buffered, and 57 feet from the addition to the southerly property line, also heavily buffered by a natural landscape screen. Finally, I'd like to submit an aerial photograph which shows that the house itself is rather diminutive compared to the much larger houses in the neighborhood, so in its entirety it has virtually no visual impact on the community. Therefore, we would respectfully submit that the variance would not pose an unwanted impact on adjacent properties. It's a minimal structure with substantial structural and natural screening. There's no ready alternative. It's a sunroom, mudroom off the garage, and back entrance to the house could not have been placed anywhere else, and it's been there since the 1970s with no environmental impact to speak of. Although created by our predecessor, we understand that this is a self-created hardship, but we would suggest that should not be a bar to granting the variance, and would therefore respectfully request the board's consideration.
Thank you. Planning? Gentlemen?
No.
Thank you so much.
Good evening.
Good evening. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
It's readily moved and second. All in favor?
Aye.
Aye, motion carried. Yes. All right. Yeah, we'll just take a 10-minute break.